Yeah, good afternoon. Let's begin with the RJS crash course. The subject is Sale of Goods Act. Fine. Sale of Goods Act 1930. Before this legislation, do you have any idea as to in which legislation the provisions of Sale of Goods Act was contained? In the Indian Contract Act. We had chapter 7 of the Indian Contract Act, in which the provisions related to sale of goods were contained. But those provisions were not so much clear, and various definitions as we have in the Sale of Goods Act, they were not there, like the agreement to sell, sale and agreement to sell, the difference between them. Then conditions and warranties, there was some confusion between them. Fine. Therefore, a new legislation was intended to be passed, and then in 1930, a new act, that is the Sale of Goods Act, in fact the Indian Sale of Goods Act. Try to remember this point, they may ask in MCQ. The Indian Sale of Goods Act was the previous name of this act. The word Indian was removed by the amendment in 1963. Fine. So this Sale of Goods Act now is the act which we intend to study for the purpose of RJS. Fine. Now, before formally starting the subject, let me tell you 1-2 points, important points for the purpose of this exam. The pattern of questions which they ask in RJS is generally direct questions, basically from the bare act. Fine. Now, since this Sale of Goods Act is a newly introduced subject this year, fine, so we do not have any previous year questions on this subject in the RJS PYQs. Fine. So what we have tried to do is that we have even segregated the questions of this subject from the examinations conducted by various states, and that we shall be doing at the end of this class. Fine. Now, coming to the act. The Sale of Goods Act 1930. Fine. This Sale of Goods Act, see, we shall be doing as per the exam pattern, strictly as per the exam pattern, because we have to finish this subject in 2 years. In 2 hours, in fact. Sorry. Fine. So come to the pattern of questions, the bare act and all directly. The Sale of Goods Act. First and foremost thing, try to remember the number of sections in the act. In any act, try to remember the number of sections. This Sale of Goods Act has 66 sections. 66. We have 66 sections in this act. These 66 sections are divided into 7 chapters. Fine. So, Sale of Goods Act has 7 chapters which has 66 sections in it. Fine. Now, as the name suggests, the sale and goods. What is this sale? What are goods? This sale in this legislation basically means the transfer of ownership. Transfer of ownership. Fine. Transfer of ownership of what? What is the subject matter? Transfer of ownership of goods. Transfer of ownership of goods. Fine. This is the subject matter, goods. Fine. These goods, are these goods movable or immovable properties? These goods are movable properties. These goods are movable properties. So, we can validly infer that this Sale of Goods Act deals with the transfer of ownership, maybe along with transfer of possession of certain movable properties. Fine. Again, these goods, for your understanding, just flip to section 2 clause 7. Section 2 clause 7. It says that goods means every kind of movable properties, every kind of movable property other than actionable claim and money. Now, write one small sentence that goods means every kind of movable property other than actionable claims and money. Means these actionable claims and money, they are also movable properties. One question may be asked as to whether these actionable claims and money, though they are not goods, but are they movable or immovable properties? Fine. So these actionable claims and money, they are also movable properties, but they are not under the purview of the term goods for the purpose of section 2 clause 7 of the Sale of Goods Act. Goods means every kind of movable property other than actionable claims and money, and includes stocks, shares, growing crops, grass, things attached to or forming part of the land which are agreed to be severed before sale or under the contract of sale. Means though these elements like grass, growing crops, things attached to earth, stocks, shares, these are movable properties, but as far as these things attached to earth are contained, they will be considered as movable properties only when they will be severed, they will be removed from the ground. Fine. Okay. If you read Transfer of Property Act, even in that you will see that transfer of property, rather transfer of immovable property, has certain elements, and those immovable properties are divided into again 3 categories and all that. So even in that they say that immovable property is land, things attached to earth, fine, and then movable properties are those things which may be though attached to earth, but they will but they can be severed before sale or agreement to sell, fine, or contract of sale. Fine. Come back. Come back to again the Sale of Goods Act. The name of the subject. Goods you have understood. Sale. Sale is the transfer of ownership of property. Fine. This word transfer, what does this mean? This transfer means creation of new rights. Creation of new rights. Fine. Therefore, you might be knowing that partition is not a transfer. Surrender is not a transfer. Fine. So if there are creation of new rights, then only transfer comes into existence. Fine. So this sale means transfer, and transfer means creation of new rights. Fine. So if I sell my watch to someone, I lose my right over that watch, and that another person, the buyer, gets a new right over my watch. Fine. Then only sale takes place. Fine. So again, Sale of Goods Act means transfer of creation of new rights in one person and abdication of right in some other person. Fine. This act is an act to define and amend the law relating to the sale of goods, and whereas it is expedient to define and amend the law relating to sale of goods, it is hereby enacted as follows. Fine. Now come to the provisions of this act. Fine. Yes, one more thing. One question may be asked from here. This Sale of Goods Act received the assent on 15th March 1930 and it came into force on, any idea? 1st July 1930. Fine. Now, we shall be reading the bare act and I shall be explaining as and where necessary. Along with that, I'll be telling you those points from where the questions in the prelims can be asked. Chalo. Rather, we shall be coming to the definition after reading one or two sections. Come to section 4 first. Section 4. Section 4 deals with formation of the contract. Now, in a minute, try to understand what this Sale of Goods Act is with respect to the Indian Contract Act. Fine. In the Indian Contract Act, a contract is an agreement enforceable by law. Fine. When an agreement is enforceable by law, in the light of this Sale of Goods Act, that agreement, if it is enforceable, it becomes a contract, and this sale of goods is a contract. Fine. Now, this sale of goods has some term known as sale and agreement to sell. Agreement to sell. See, one question arises from here. They may ask that section 4 defines and choose the incorrect answer. Fine. In the incorrect answer, they will write agreement to sale. Please do not get confused. Sale is something different. Agreement to sell is something different. Fine. Contract of sale. Fine. So, section 4 deals with contract of sale, in which we have sale and agreement to sell and not agreement to sale. Fine. Not agreement to sale. Fine. Because this question some other states have asked. Fine. This is a confusing question, so try to remember this. A contract of sale of goods is a contract. Again, section 2H of Indian Contract Act, which you might be knowing, an agreement enforceable by law. Contract of sale of goods is a contract whereby the seller transfers. When the seller transfers, this becomes, when the seller transfers, this becomes sale. A sale has been completed. Fine. or agrees to transfer property in goods. Agrees to transfer means it is agreement to sell. Correct? The property in goods, this property is the ownership in goods for a price. This price is section 2D Indian Contract Act, in which they have written consideration. Fine. That price is a consideration. There may be a contract of sale between one part owner and another. Means if I partly own certain thing with someone else, I can enter into a contract of sale with some third person to transfer those goods on which I have a right. See, there is one general provision that no person can transfer a better title than he himself has. Therefore, a person who does not have a title cannot transfer that property, though it has certain exceptions. We will see to it in the later stage. Fine. The general principle is that of nemo dat quod non habet. That is, no person can transfer better title than he himself has. So, a part owner, he has ownership over that part of the property, he can sell it to someone else. No issues in that. Fine. Contract of sale may be absolute or conditional. Absolute, again one question we get from here. Contract of sale can be, first option, absolute. Second one, conditional. Third one, either absolute or conditional. Fourth one, none of the above. Fine. So third one, it can be either absolute, that is without any conditions, or conditional depending upon certain preconditions. Fine. For example, I will be selling my car to you provided you give me 3,000 rupees in advance. Fine. Then only I will be selling the car to you. The remaining amount I may be taking at a future date, but the initial amount I want it from you. That is a precondition. Fine. A sale can be conditional also. Third clause, where under contract of sale, the property in the goods is transferred from the seller to the buyer, means a sale has been executed. The property has been transferred from the seller to the buyer. The contract is called a sale. Fine. This sale. But where the transfer of property in the goods is to take place at a future time or subject to some condition thereafter to be fulfilled, contract is called an agreement to sell. This one, an agreement to sell. Fine. And the fourth clause states that agreement to sell becomes a sale when the time elapses or the conditions are fulfilled subject to which the property in goods is to be transferred. Means this agreement to sell, which is a right in personam, again a new question. Agreement to sell is a right in personam and sale is a right in rem. Right in personam, personal right. Right in rem, right against the whole world. This agreement to sell, which is a right in personam, becomes a sale, which is a right in rem, once the conditions are fulfilled or time, the maximum time which was given for the buyer to take the property and to pay the price, that time has elapsed and he has paid the price, or whatever be the condition there in contract. Fine. So this agreement to sell has to eventually become a sale for that contract to get executed. Fine. Keep on writing the points from where I tell you that questions may be asked. Keep on writing the points. Now this contract of sale, which can either be a sale or agreement to sell. Section 4 states that this contract of sale can either be a sale, S-A-L-E, or agreement to sell, S-E-L-L. Fine. This contract of sale, how is it made? How is it performed? What is the procedure? Fine. Next MCQ, the procedure for contract of sale is given under section 5. Fine. Keep on writing the points, keep on writing the MCQs. Fine. Once the subject is completed, I don't think you will be getting any questions out of this session. A contract of sale is made by an offer to buy or sell the goods for a price and acceptance of such offer. See, again come back to contract. Contract is an agreement enforceable by law. An agreement according to section 2E of the Indian Contract Act is what? What is an agreement? See, go. Huh? What? Promise or set of promises. Fine. Set of promises is reciprocal promise. There can be a promise or a set of promises forming consideration for each other. Fine. This contract of sale is made by an offer or proposal. Fine. That offer is to be accepted by the other person, offer by the seller, acceptance by the buyer, and consideration, that is price to be paid by the buyer. Fine. So this contract of sale, the procedure is that I as a buyer shall be offering you to sell my goods. You shall be accepting my offer. You shall be paying me the consideration. Then this sale gets complete, executed. And contract may provide for the immediate delivery of the goods or immediate payment of the price, or both, or for the delivery or payment by installments, or that the delivery or payment or both shall be postponed. See, again try to understand. Contract. Contract, always remember one thing. Contract is not a law like you have the Code of Civil Procedure, fine, or Bharatiya Sakshya Adhiniyam, or Specific Relief Act. Fine. Contract is a law between the parties, and the parties make the rules of contract. Fine. This Sale of Goods Act, being a contract, the parties to the contract are free to make the terms of contract, formulate the terms of contract, and such term can be that the delivery of the goods shall be made forthwith, that is immediately, or the payment of the goods, payment for the goods shall be made immediately. Fine. Payment shall be made immediately, delivery may be postponed, delivery may be made immediately, payment may be postponed, or both the situations can be done. Fine. I purchase the goods, I shall be paying you in 20 minutes. Fine. And delivery I shall be taking after payment of the price, and that can be done. Or for the delivery or payment by installments, suppose I have to purchase 10 kg of rice, I agree with the seller that I shall be paying for 2 kgs on every alternate days for 5 days, and that person shall be giving me 2 kg of rice on every alternate day. Delivery and payment both may be postponed, or both may be by installments, or that delivery or payment both shall be postponed, that I told you just now. Subject to the provisions of any law for the time being in force, contract of sale may be made in writing or by word of mouth. Again another question. Contract of sale can be either oral or in writing, or both, or partly in writing or partly by word of mouth, and may be implied by the conduct of the parties. Fine. So it can either be in oral, it can be in writing, it can be through conduct. Fine. Suppose, again take one example. Suppose for conduct. Suppose I am the seller, you are the buyer. You come to my counter at my shop. You give me 200 rupees and you need to take a notebook for 200 rupees. I take that amount. I tell you that go there on the rack, on the shelf, take that copy. Fine. You have performed your obligation. I have performed my obligation. I have told you to go there and take the copy. So through my conduct, or suppose I am talking on phone, I take the money from you. I show you through my finger that go and take the copy from there. Fine. That is by conduct. Fine. Now, you have again, here we were studying the procedure for that contract. Now, the subject matter of the contract. What is the subject matter? Subject matter are goods. Fine. Section 6 states that the goods which form the subject matter of contract of sale may be either existing goods owned or possessed by the seller or future goods. What are these existing goods and what are these future goods? Fine. Existing goods are those goods which the seller has with him at the time of contract of sale. Future goods are those goods which the seller may acquire in future, or such goods which are yet to be produced. Fine. In the future goods, write one more category. We have something called as contingent goods. You have in this second paragraph, the goods can be of three kinds. In fact, if you say two kinds, then future and existing, and in future you have one subtype, that is contingent goods. Suppose a farmer enters into a contract with someone to sell 10 gunny bags of rice, and those rice, that rice for which the contract of sale is there, that rice is yet sown, that has not been reaped. So अभी तो बस वो डाला गया ना उगने के लिए, ठीक है. So it is a contingency whether that will ripe or not, isn't it? So that is contingency. It depends upon a future uncertain event. Fine. So contingent goods are also there. In clause 2 we can see that there may be a contract for sale of goods, the acquisition of which by the seller depends upon a contingency which may or may not happen. Fine. So goods can be, suppose they give a MCQ that goods can be existing, future, contingency, and the fourth option will be, rather three options will be there. Sometimes what they do, no? See, analyze this type of question once. Just wait. See, what they do sometimes, when they give the options, they'll ask you a question. Ask you a question. They will give three options like this, 1, 2, 3. Now the main options will be, option A will be 1 and 2 both. Option B can be 1 only. Option C can be 2 and 3 only. And option D can be all 1, 2 and 3. So be ready for these kinds of questions also. Now, in the case of goods, if they tell you that goods can be either existing, future, contingent, sorry, the options are 1 and 2 both, 1 only, 2 and 3 both, 2 and 3 only, and 1, 2 and 3 all. So the fourth option will be correct. Fine. The third clause of section 6, whereby a contract of sale, seller purports to effect a present sale of future goods. Contract operates as an agreement to sell the goods. Now, suppose a contract is between the buyer and the seller, and what the seller has to sell is those goods which are not yet in existence. Fine. If the seller purports, this word purports means purports. See, purports means, what does this mean? Any idea? It means acknowledges. Fine. He acknowledges. He simply acknowledges to effect the present sale of future goods, the goods which are yet to be manufactured or produced. So such a contract operates merely as an agreement to sell, because the goods are not yet in existence. So that person, the buyer, cannot take possession of the goods. The goods are not in, you have a word called as deliverable stage. Deliverable stage. Now this is the right time when we shall be going to section 2. Fine. So this is a state in which the buyer is bound to take the goods. Now if the goods are not yet in existence, what will the buyer take? Therefore, here it says that if the seller merely purports, acknowledges to sell the goods, it operates as an agreement to sell. Mark this as very important for MCQ. It operates as agreement to sell and not a sale. Fine. Now come back to section 2, the definition clause. In this act, unless there is anything repugnant to the subject, in the subject or context. Buyer means a person who buys or agrees to buy the goods. No issue in this. Delivery means voluntary transfer of possession from one person to another. Now, here we again get one more question. Where we had studied sale of goods, sale was transfer of ownership. That transfer of ownership, that fine. So this is the main subject matter. This is the ancillary subject matter. There can be even possession without ownership, without transfer of ownership. Fine. So delivery means voluntary transfer of possession from one person to another. Fine. Here delivery need not be transfer of ownership. Fine. It can be transfer of ownership, can be transfer of possession also. Fine. So mark this answer. Mark this, in fact, definition for MCQ. Goods are said to be in deliverable state. What I had told you just now. When they are in such a state that the buyer would under the contract be bound to take delivery of them. Goods can be delivered, goods are in deliverable state, so the buyer is bound to take the delivery because there is a contract between the seller and buyer, and if the buyer does not take it, once the seller makes it in deliverable state, if the buyer does not take it, then the seller may incur losses. Therefore, once the goods are in deliverable state, the buyer is bound to take the possession of those goods. Fine. Document of title of goods. What is this? You just understand the simple language that this document of title is any receipt, is any piece of paper through which you get the ownership of the goods. Suppose you sell, suppose you transfer your belonging through a railway. You transfer your bike through a railway, through train. Fine. They give you a railway receipt. Fine. That railway receipt is document of title of goods. Means in that document, the ownership of goods is mentioned. The person who is the owner, his name is mentioned in that document of title of goods. It can be bill of lading, dock warrant, warehouse keeper's certificate, wall finger certificate, and all. Fine. Or any other document used in ordinary course of business as the proof of possession or control of goods, or authorizing or purporting to authorize either by endorsement or delivery the possessor of the document transfer or receive the goods thereby represented. Means I give my bike to be in transit from Delhi to Calcutta. In Calcutta, the person who needs to take the bike, he shall give that railway receipt to the railway person who is in possession of the goods. Then only that possessor, that railway person, will be transferring that bike, will be handing over that bike to this person. Fine. So these piece of papers are document of title to goods. Fault means wrongful act or default. One more thing, try to remember this, that fault means wrongful act and not illegal act. The 4 options may be: first one, fault means wrongful act; second one, default; third one, illegal act; fourth one, all of the above. Fine. And the question will be choose the incorrect answer. Fine. Illegal act will be incorrect. Let's move forward. Future goods. They are the goods to be manufactured or produced or acquired. To be manufactured or produced or acquired by the seller after the making of contract of sale. Fine. After the making of contract of sale, those goods will either be manufactured in totality, produced in totality, or they might have been manufactured but the seller has not yet acquired. He will be acquiring at a future date. Fine. So this is future goods. And goods you have studied, every kind of movable property other than actionable claim and all. Person is said to be insolvent. Right here, a person is said to be adjudicated insolvent, who has ceased to pay his debts in the ordinary course of business or cannot pay his debts as they become due, whether he has committed an act of insolvency or not. Fine. This insolvent we will be looking once we see the stoppage in transit. Stoppage in transit we have under provision once we come forward. So वहाँ पे insolvent की बात आएगी. Mercantile agent means agent in the ordinary course of business. As such, agent authority either to sell goods or consign goods and all. Means you just try to remember the clause number Fine, mercantile agent. He is a simple agent who does the business. In the course of business, he acts on behalf of the principal. जनरली देखो डेफिनेशन क्लॉज किसी भी सेक्शन का ना, किसी भी एक्ट का ना, डेफिनेशन क्लॉज में हमेशा डेफिनेशन के वो क्लॉजेज के नंबर्स याद रखना, हमेशा, वो कभी भी पूछ लेते हैं. और गुड्स के लिए और मर्केंटाइल एजेंट के लिए ये तो बहुत बार पूछे हैं कि गुड्स कौन से प्रोविजन में डिफाइंड है और मर्केंटाइल एजेंट कहाँ पे डिफाइंड है, तो ये दोनों याद रखना. प्राइस मीन्स मनी कंसिडरेशन फॉर सेल ऑफ गुड्स. Property means general property in goods and not merely special property. Now, one question they have asked. देखो, general property in goods. Property से यहाँ पे we understand ownership. Fine. So, property means general property of goods. General property in goods. Sorry. Fine. Means the transfer of general property, transfer of ownership, and not merely special property. Not only special property. Special property means the ancillary property which is transferred along with the general property. Means possession, right to use the property. Fine. So it not, suppose you, if you can remember one provision of the Transfer Property Act, that is usufructuary mortgage. Usufructuary mortgage. The right to enjoy the usufruct of the mortgaged property, right to enjoy the profit of the mortgaged property. So there the property is not transferred, but something ancillary to the transfer of ownership is done. Fine. Right to enjoy the property, right to take the benefit, right to take the ownership from that property. So here also it says that not merely right to possession, not merely right to the use of that property is there, but property means also the general property in goods, means the ownership in the goods. Fine. Quality of goods includes their state or condition. Seller means a person who sells or agrees to sell the goods. Specific goods means the goods identified or agreed upon a time of contract of sale is made. Specific goods. The goods which are agreed at the time of sale. Fine. Unascertained goods. The goods which are not yet ascertained or not capable of being made certain presently. Fine. And the expressions used and not defined in this act, वहाँ पर we shall take recourse to the Indian Contract Act and write in clause 15, please write para materia. Paramateria, clause 15. So they may ask that the expressions which are not defined here, can we take recourse of any other legislation? That is Indian Contract Act. Fine. Now again, come back to the provisions from where we had left. Section 6 was done. Yeah. Section 7 now. Correct, section 6 was done. No? Come to section 7. Section 7. Goods perishing before making of contract. Where there is a contract for sale of specific goods, the contract is void. See, I wish to make a change here. Contract is never void. Contract becomes void. Let's read again. Where there is a contract for sale of specific goods, contract becomes void if the goods without the knowledge of the seller have, at the time when the contract was made, perished or become so damaged as no longer to answer to their description in the contract. Once the contract was made, fine. Subsequent to the making of the contract, the seller did not know, the buyer, however, he did not know, but the seller, even the seller did not know, and the goods perished. So if the goods perished, this seller has nothing to give to the buyer. Fine. This contract, which was earlier a valid one, contract is always valid. Fine. Agreement may be void. Fine. But contract is always valid. So this contract becomes void when the goods have so perished. Fine. They are saying that where a contract of sale of good, where there is a contract for sale of specific goods. Fine. Now there is a contract for sale of specific goods. The seller does not know, and the goods have lost their importance. The goods have perished. Fine. So that contract becomes void. And if the goods without the knowledge of the seller have at the time when the contract was made perished or become so damaged as no longer to answer their description in the contract, means the purpose for which those goods were to be bought, that purpose cannot be accomplished now. So the contract becomes void. Fine. Neither the buyer needs to pay anything to the seller, nor the seller needs to compensate the buyer. Fine. In this case. Now, goods perishing before sale but after agreement to sell. There has been an agreement to sell between the buyer and the seller, but the actual sale has not been executed and the goods have perished in the meanwhile. So where there is an agreement to sell specific goods and subsequently the goods without any fault on the part of the seller or buyer perish or become so damaged as no longer to answer to the description in the agreement before the risk passes to the buyer, before the buyer takes those goods, agreement is thereby avoided. Here also the buyer need not compensate the seller need not do anything in favor of the buyer. Fine. There was merely an agreement to sell. And without any fault on part of the seller or buyer, the goods have perished. Write this important for MCQ. What they do is that in place of this without, they just write with or by the fault of the buyer or seller. Understand one thing again. Whenever you read any question in the question paper in the examination hall, do not think that if you complete your paper before the stipulated time, you will be getting some award. Do not think that. If they have given you 2 hours for the paper, there is something in their mind by which they have decided that 2 hours will be enough. Otherwise, they could have given 1 hour. Fine. So read the question very carefully. Read each and every word in the question and then only answer. Fine. These are the mistakes which we make and which lead to our non-selection or rejection. Fine. So do not make these mistakes. Once you give the examination, if you do not qualify and you check your answers in the answer sheet, I guarantee you, देखो अगर तुमने एकदम ही पढ़ाई नहीं की है तब तो कुछ नहीं बोल सकता हूँ, लेकिन अगर तुम पढ़ाई करके गए हो और उसके बाद अगर तुम्हारा सिलेक्शन नहीं हो रहा है तो मियरली 5 से 6 क्वेश्चंस रहेंगे जिसके कारण तुम्हारा सिलेक्शन नहीं हुआ होगा, है ना. तो इन 5-6 क्वेश्चंस को गलत नहीं करना है. और ये 5-6 क्वेश्चंस ऐसे ही गलत होते हैं जब आप आधे क्वेश्चन पढ़ के आंसर देते हो या आप वो OMR शीट में ओवल इनकरेक्टली मार्क कर देते हो. ये भी होता है, 1-2 ये भी होता है. ठीक है. तो ये 2 मिस्टेक कभी मत करना. शांत दिमाग से क्वेश्चन पढ़ो और आंसर लिखो. Now comes the consideration wala part. Price. How can the price be ascertained? Means how can the price be made certain? Fine. This price can be made certain in 3 ways. According to section 9, this price can be made certain. This price can be ascertained in 3 ways. The first one, price in a contract of sale. may be fixed by the contract. First one, may be fixed by the contract, or may be left to be fixed in the manner thereby agreed, or may be left to be fixed in the manner thereby agreed, may be left to be fixed in the manner by some valuator, by someone else, जो सेक्शन 10 में है. फाइन. और may be determined by a course of dealing, determined by the course of dealing between the parties, may be determined by the course of dealing between the parties. जो जनरल रूल होता है कि द पार्टीज डिटरमाइन द प्राइस. फाइन. सो दीज आर द थ्री वेज. एक बार इन्होंने किसी स्टेट में पूछा है, मुझे याद ये नहीं है, इन्होंने सिंपली ये पूछ लिया है कि फॉर द एसरटेनमेंट ऑफ प्राइस हाउ मेनी वेज आर मेंशन्ड इन द स्पेसिफिक रिलीफ एक्ट, स्पेसिफिक in the sale of goods act. Fine. So here we have three ways in which a price can be determined. Fine. Where next clause, where the price is not determined in accordance with the foregoing provisions, ऊपर में जो provisions है इससे अगर price determine नहीं हो रहे हैं, buyer shall pay the seller a reasonable price. Again they have asked this question, where the price cannot be determined, what is the price that the buyer shall pay to the seller? Reasonable price. Again next question they have asked, that this reasonable price, what is a reasonable price, is a question of fact dependent on the circumstances of each particular case. They have asked that whether this determination of price is a question of fact, it's a question of law, it's a mixed question of law and fact, and all of the above. Fine. This is a question of fact. Fine. तथ्य के आधार पर इसे निर्धारित किया जा सकता है. Fine. Agreement to sell at valuation, where there is an agreement to sell goods on the term that the price is to be fixed by valuation by a third party, and such third party cannot or does not make some valuation, agreement is thereby avoided. Once the parties are dependent upon some third person, that third person fails to perform his duty, then the main object of that sale gets frustrated and that sale can be avoided. Fine. मुझे पता ही नहीं है कि कितनी प्राइस है. मान लो मुझे एक लैंड सेल करना है. लैंड तो सेल ऑफ गुड्स में नहीं सेल होगा, ट्रांसफर प्रॉपर्टी में सेल होगा. मान लो मुझे कोई एंटीक सामान सेल करना है ना, तो मुझे पता ही नहीं है कि कितने प्राइस में मैं सेल करूंगा इसे, और जो बायर है उसे भी कोई रीजनेबल प्राइस नहीं पता है. तो हमने एक वैल्यूअर को बुलाया और उसे हमने बोला कि तुम 5 दिन के अंदर इसका प्राइस तुम फिक्स कर दो. अब वो बंदा 5 दिन के अंदर प्राइस फिक्स नहीं कर पाता है, तो द एग्रीमेंट इज अवॉइडेड. देयर इज नो पर्पस ऑफ सेलिंग दैट थिंग विदाउट नोइंग द प्राइस. फाइन. देयरफॉर द एग्रीमेंट गेट्स अवॉइडेड, प्रोवाइडेड दैट इफ द, ये प्रोवाइजो पढ़ रहा हूं, सॉरी, सेक्शन 10 का प्रोवाइजो पढ़ रहा हूं. Provided that if the goods or any part thereof have been delivered to an used by the buyer, he shall pay a reasonable price therefore. मुझे पता, लेकिन मैं उस एंटीक पीस को उस बायर को दे दिया कि 4 दिन में जो वैल्यूएशन वाला बंदा है वो वैल्यू उसकी पता करके पैसे ले लेगा आपसे, या मैं ले लूंगा. वो बंदा ले गया, मान लो एंटीक पेन था और वो उसे लिखना शुरू कर दिया, है ना. तो नाउ ही हैज एप्रोप्रिएटेड दैट थिंग. फाइन. सो देयरफॉर ही शैल पे अ रीजनेबल प्राइस देयरफॉर. फाइन. एंड वेयर सच थर्ड पार्टी इज प्रिवेंटेड फ्रॉम मेकिंग द वैल्यूएशन, जिसे हमने फिक्स किया था जिन्हें वैल्यूएशन करने के लिए, बाय द फॉल्ट ऑफ सेलर और बायर, द पार्टी नॉट इन फॉल्ट मे मेंटेन अ सूट फॉर डैमेजेज अगेंस्ट द पार्टी इन फॉल्ट. मीन्स there is a person who needs to do the valuation. This person, valuation by A. Fine. This A is prevented by buyer B from fixing any reasonable price. Buyer B goes to the house of valuer A and he tells him that ये तो सामान 2000 का है, तुम इसमें 500 ही फिक्स करके उन्हें भेजो सेलर को. This person refuses. A refuses to act in the manner as asked by B. So what A does, he does not fix a price, but B was at fault. He made such an attempt which avoided A from fixing the price. So this B shall give damages, that is compensation to A. Sorry, to the seller S. Fine? Correct? Got it? Chalo. Now come to stipulations. Stipulation. What is the meaning of stipulation? Terms. Correct? Terms. The terms on which a contract depends. Fine. There can be stipulation as to time. There can be stipulation as to some essential element of the contract. Fine. Stipulation as to time. Unless a different intention appears from the terms of the contract, stipulation as to time of payment are not deemed to be of the essence of contract of sale. Whether any other stipulation as to time is of essence of the contract or not depends upon the terms of contract. Now, see, the very first sentence says that unless a different intention appears from the terms of contract, means unless the parties have otherwise agreed, means unless the parties have deviated themselves from the general rules. Fine. So, take an example here. Suppose there is a birthday party. A birthday party is scheduled at 8 o'clock in the evening. Fine. Someone or some shopkeeper takes a contract to send a cake for the birthday party. The cake is to be sent by 7:45, 7:50. Birthday party has to be started at 8 o'clock, suppose. And it was made very much clear to the shopkeeper that the guests and everyone, and in fact the person whose birthday party was being celebrated, he needs to leave by 9 o'clock as he has flight at 10 o'clock. Suppose. Now, since all these times are fixed, fine, jam-packed. So, here time becomes essence of the contract. Take another example. Suppose एक बर्थडे पार्टी है और केक मिलना है, बर्थडे पार्टी स्टार्ट होना है 8 बजे, केक पहुंच जाना है 7:45 तक, केक पहुंचता है 9 बजे शाम में, कोई फर्क नहीं पड़ता, कोई दिक्कत नहीं है, थोड़ा लेट हो गया है ना. लेकिन इफ द सिचुएशन इज मेड or if the situation is told to the shopkeeper, then the shopkeeper must act accordingly. Their time acts as the essence of contract. Fine. Therefore they have written unless a different intention appears from the contract. अगर इन्होंने बोल दिया है टाइम एसेंस होना है तो फिर टाइम एसेंस होना है, नहीं तो कॉम्पनसेशन देना होगा. Stipulation as to time is of essence of the contract or not depends upon the terms of contract, जो मैंने अभी बताया. अब इसके अलावा जो इंपॉर्टेंट स्टिपुलेशंस है, टर्म्स है, जो आपके एग्जाम में पूछेगा, पक्का पूछेगा, वो है कंडीशन एंड वारंटी. फाइन, पक्का पूछेंगे ये लोग. कंडीशन, Section 12, a stipulation, a term in a contract of sale with reference to goods which are subject thereof may be a condition or a warranty. This condition is a stipulation, is a term essential to the main purpose of the contract, breach of which gives rise to a right to treat the contract as repudiated, and warranty is a stipulation collateral to the main purpose of the contract, the breach of which gives rise to a claim for damages, not a right to reject the goods and treat the contract as repudiated. Means आप एक क्वेश्चन लिख लो that there is something called as condition, something called as warranty. It is the essence of the contract. It is something collateral to the main purpose of the contract. The breach of this gives rise to repudiation of contract. The breach of this gives rise to claim for damages. एकदम याद रखना ये. Fine, done. So condition and warranty. Now these conditions and warranties can either be express or implied. फाइन. कभी ऐसा क्वेश्चन ये लोग पूछ लेते हैं कि सिंस कंडीशन इज समथिंग एसेंशियल टू द कॉन्ट्रैक्ट, सो कैन अ कंडीशन बी इम्प्लाइड. फाइन. और सच अ कंडीशन कैन बी एक्सप्रेस, इम्प्लाइड, आइदर ऑफ देम, नन ऑफ द अबव, या ऐसा कुछ भी है ना. It can either be expressed or implied. Now, fourth one, very important. Fourth clause, section 12. And section 13 flows from this fourth clause. Where a stipulation is in a contract of sale is a condition or a warranty, depends in each case on the construction of the contract. A stipulation may be a condition, though called a warranty in the contract. इसलिए यहां पे पहले लिखा हुआ था ऊपर में, इससे ऊपर था, या कहीं भी आप कॉन्ट्रैक्ट कहीं देख लो, छोड़ो. कॉन्ट्रैक्ट में टर्म्स ऑफ द कॉन्ट्रैक्ट आर फिक्स्ड बाय द पार्टीज. फाइन. देयरफॉर कोई कॉन्ट्रैक्ट में ये लिखा रह सकता है कि जो टर्म है इट इज अ वारंटी, लेकिन इट मे बी अ कॉन्ट्रैक्ट, इट मे बी अ कंडीशन. फाइन. सो दैट हैज टू बी गैदर्ड फ्रॉम द इंटेंशन ऑफ द पार्टीज टू द कॉन्ट्रैक्ट. फाइन. And when this condition can be treated as warranty, where a contract of sale is subject to any condition to be fulfilled by the seller, buyer may waive the condition or elect to treat the breach of condition as warranty, not a ground for treating the contract as repudiated. मान लो एक कोई condition है, तो buyer may himself tell the seller that I do not require this as a condition, this as an essential part of the contract. Rather, if you fail to perform your obligations, just give me damages for it. Fine. Then such a condition may be treated as warranty. Fine. The crux is that whether any term is a condition and or warranty, that depends upon the term of the contract that is to be fixed by the parties. Fine. Where a contract of sale is not severable, and the buyer has accepted the goods or part thereof, breach of condition to be fulfilled by the seller can only be treated as breach of warranty, not a ground for rejecting the goods and treating the contract as repudiated, unless there is a term in a contract to that effect, express or implied to that effect. Suppose the buyer has taken part possession of the goods. Fine. So then, if the goods turn out, not to serve the purpose properly, then such a condition, then such a term, in fact, cannot be treated as condition. Rather, it will be treated as merely a warranty, and the seller has to pay damages, but the buyer cannot return the goods. Fine. Take one example. You do online shopping. Fine. Suppose you take you purchase you purchase a jeans from Flipkart. Fine. अब देखो, लोग तो एक से एक होते हैं ना, वो जीन्स लेंगे और वो पहन के कहीं घूमने चले जाएंगे, वहाँ से वापस आके वापस कर देंगे फ्लिपकार्ट को. ठीक है. तो वंस यू हैव यूज्ड द जीन्स, यू कैनॉट रिटर्न इट. भले ही वो खराब निकला, अगर वो सही कपड़ा नहीं निकला, तो यू मे फाइल अ सूट अगेंस्ट द कंपनी ऑफ दैट जीन्स. Fine, you may claim damages for it, but you cannot return it because you have appropriated the thing. Fine. Therefore, आजकल आप लोग देखोगे मोस्टली ऑनलाइन प्लेटफॉर्म्स में ओपन बॉक्स डिलीवरी दे रहे हैं, है ना, ओपन बॉक्स डिलीवरी, सो दैट यू कैन चेक द थिंग्स. फाइन. भले ही साइज अगर छोटा बड़ा है तो यू कैन रिटर्न इट. फाइन. एक और चीज़ आप उसमें नोटिस करोगे, आजकल वो क्या करते हैं, जब बटन रहता है ना, वहाँ पे एक वो स्ट्रिंग लगा देते हैं. वो स्ट्रिंग यू कैनॉट रिमूव अनलेस यू कट इट विद अ सीजर. तो तुम वो पहन के कहीं जा ही नहीं सकते हो ना. वहाँ तो टैग लगा हुआ है. टैग तो तुम मान लो मेरे शर्ट में टैग लगा हुआ है, तो मैं वो टैग को अंदर करके पहन के चला जाऊँ, लेकिन वो शर्ट के बटन में ही एक स्ट्रिंग लगा देते, बटन का वो जो रहता है जहाँ वो बटन डालते हैं हम, तो मैं कहीं भी पहन के जाऊँगा तो वो तो सामने दिखेगा ही ना, मैं तो काट ही नहीं सकता हूँ. ठीक है. तो इसलिए आजकल ऑनलाइन प्लेटफॉर्म में ऐसा कर रहे हैं, क्योंकि ताकि आप ये नहीं करो कि तुम अप्रोप्रिएट करके भी सामान वापस कर दो, है ना. Nothing in this section shall affect the case of any condition of warranty fulfillment of which is excused by law by reason of impossibility or otherwise. Now, if a thing has been sold and कुछ ऐसा हो जाता है कि उसे वो रिटर्न नहीं किया जा सकता है, तो उसमें कंडीशन वारंटी कुछ भी नहीं काम करेगा. Implied undertaking as to title, etc. Unless the circumstances of the contract are such to show a different intention. Implied condition on the part of the seller that in the case of a sale, he has a right to sell the goods, that in the case of agreement to sell, he will have a right to sell the goods at the time when the property is to pass. At the time of sale of goods, he needs to give the property to the buyer. At the time of agreement to sell, he needs to give the property to the buyer at the time which was decided by the contract, because agreement to sell is again just a right in personam. Fine. Therefore, and an implied warranty, ये important mark करो, बहुत बार बहुत सारे स्टेट में पूछा कि implied warranty के बारे में कहाँ पे दिया हुआ है. Implied warranty, an implied warranty that the buyer shall have and enjoy quiet possession of the goods. An implied warranty that the goods shall be free from any charge or encumbrance in favor of any third party, not declared or known to the buyer before or at the time when the contract is made. Now, sale by description and sale by sample. सेल बाय डिस्क्रिप्शन, सेक्शन याद रखना 15, सेक्शन 16 तो बहुत इंपॉर्टेंट है, पूछता है, दे आस्क रूल ऑफ केविएट एम्प्टर. व्हाट इज दिस केविएट एम्प्टर? What is this caveat emptor? Buyer beware. Fine. Let's see section 15. When there is a sale by description of the property, so the property must correspond to that description which has been given by the seller. Fine. Where there is a contract for the sale of goods by description, there is an implied condition that the goods shall correspond with the description. And if the sale is by sample as well as by description, it is not sufficient that the bulk of goods corresponds with the sample only. Sample only. If the goods do not also correspond with the description, means जिस डिस्क्रिप्शन का आप गुड्स खरीद रहे हो, जो आप सेलर को अवेयर कराए हो, गुड्स उन्हीं डिस्क्रिप्शन के होने चाहिए. फाइन. एंड वंस स्किप सेक्शन 16, कम टू 17. एक बार 17 में आओ, फिर 16 में आएंगे वापस. सेल बाय सैंपल. Contract of sale is a contract for sample, it's contract for sale by sample, where there is a term in the contract express or implied to that effect, and in the case of a contract of sale by sample, there is an implied condition that the bulk shall correspond to the sample in quality. अब मान लो आप जाते हो कोई सामान लेने के लिए और आपको सपोज वो 10 पीसेज कोई क्लोथ के लेने हैं, कपड़े के 10 पीस लेने हैं. वो एक तुम्हें डिस्क्रिप्शन में एक सैंपल वो दिखा दिया कि इन्हीं सैंपल के सब कपड़े हैं. तो तुम एक बार जब देख लिए तो इट इज द ड्यूटी ऑफ द शॉपकीपर टू गिव यू द क्लोथ्स ऑफ दैट सैंपल ओनली. यू कैनॉट चेंज द सैंपल्स, कैनॉट चेंज द क्लोथ्स इन बिटवीन. In the case of contract for sale by sample, there is an implied condition that the bulk shall correspond with the sample in quality, and that the buyer shall have a reasonable opportunity of comparing the bulk with the sample, and that the goods shall be free from any defect rendering them unmerchantable, which would not be apparent on reasonable examination at sample. Means the goods shall be free from any latent defect. There are two kinds of defects, patent and latent. Latent you cannot see, छिपा हुआ है. So those goods shall be free from any latent defect. Patent तो आप सामने देख के समझ जाओगे ना. अगर आपको याद होगा, पहले ऐसा एक एडवर्टाइजमेंट आता था कि कोई शॉपकीपर्स अपने एडवर्टाइजमेंट्स करवाते थे कि ये कपड़े हैं और इसमें इतने छोटे से वो कटे हुए हैं जो आपको देखने से भी नहीं पता चलेगा. कुछ ऐसा आता था, मुझे याद आ रहा है थोड़ा. फाइन. तो दैट वाज पेटेंट डिफेक्ट. आप देख के पता कर लो, अगर पता कर सकते हो तो. वो तो बोलो आपको देखने से पता नहीं चलेगा, पता कर लो फिर मत लो. लेकिन अगर वैसे ही कोई लेटेंट डिफेक्ट, अभी मान लो कोई एक पर्पस के लिए मुझे कोई जैकेट लेना है, ठीक है, और जैकेट ऊपर से देखने में तो बड़ा अच्छा है लेकिन अंदर से उसकी क्वालिटी बहुत खराब है, तो मैं पता नहीं कर सकता हूँ ना. So the shopkeeper which has been assigned with the duty to give me the jacket of that description shall give the jacket of that description which suits to my जो मुझे चाहिए उससे वो सूट करता है. फाइन. तो वो that is the duty of the seller. फाइन. Now come back to 16. Implied conditions as to quality or fitness. Subject to the provisions of this act and to any other law for the time being enforced, there is no implied condition or warranty as to the quality or fitness of for any particular purpose of goods supplied under a contract of sale except देखो, general rule is that there is no implied warranty or condition as to quality or fitness of goods. Fine. मान लो क्वालिटी तुम सोच रहे हो कि वो 100 में तुम्हें 90 मार्क्स दो, वैसी क्वालिटी है, हो सकता है क्वालिटी 40 मार्क्स वाले रहे, तो उसके लिए कोई कंडीशन वारंटी नहीं है। लेकिन देयर आर फ्यू सिचुएशंस जहां पे देयर आर इम्प्लाइड कंडीशंस एंड वारंटी। फाइन। General rule is that caveat emptor, that is the buyer must be aware. Fine. But there are certain situations जहां पे buyer को beware होने की जरूरत नहीं है, seller भी अपने judgment के according काम करेगा. First one, where the buyer expressly or by implication makes known to the seller particular purpose for which the goods are required, so as to show the buyer relies on seller's skill or judgment, and the goods are of a description which are in the course of seller's business to supply, whether he is the manufacturer, producer or not. There is an implied conditions that the goods shall be reasonably fit for such purpose. Means मैं अगर दिल्ली में हूँ और मैं अगर मान लो दिसंबर जनवरी का मंथ है ना, आई नीड अ जैकेट, तो आई गो टू डी कैथलॉन, और डी कैथलॉन में जाता हूँ, तो मैं तो ये सोचता हूँ ना कि मुझे इस ठंड के लिए जैकेट की ज़रूरत है, और वहाँ पे 10 क्वालिटीज़ के जैकेट्स हैं, तो मैं वो शॉपकीपर को बुलाता हूँ और उसे बोलता हूँ कि मुझे ऐसी जैकेट चाहिए जो दिल्ली के 6 डिग्री की ठंड को भी बर्दाश्त कर ले, है ना। तो ये मैं उसे अवेयर करवा दे रहा हूँ, तो आई नीड नॉट बी अवेयर नाउ, केविएट एम्प्टर मेरे पे नहीं लग रहा है ना। अब वो बंदा, वो शॉपकीपर जो है, वो मुझे उस क्वालिटी का जैकेट देगा जो मैं उसे अवेयर कराया हूँ। सो दिस इज एन एक्सेप्शन टू केविएट एम्प्टर। हाउएवर, प्रोवाइडेड दैट in case of contract of sale for a specified article under its patent or other trade name, there is no implied condition as to fitness for any particular purpose. अगर वो पेटेंटेड ही है तो उसमें कोई जरूरत ही नहीं है उसकी ना, है ना। Where the goods are brought by description from a seller who deals in goods of that description, there is an implied condition that the goods shall be of merchantable quality. Now suppose I need to purchase some bottles of coconut oil. I go to a shop which deals with leave coconut oil. I'll give you one live example. I had to purchase a sofa set. Fine. और मुझे वो शीशम का ही सोफा सेट चाहिए था, तो what I did, I went to a shop in Greater Noida यहाँ पे, जो सिर्फ शीशम के आर्टिकल्स से डील करते हैं, है ना। तो वो सिचुएशन आपका यहाँ पे आ गया, bought by description from a seller who deals in goods of that description only. There is an implied condition that the goods shall be of that शीशम की लकड़ी. Fine. And provided that if the buyer has examined the goods, there shall be no implied condition as regards the defects which such examination ought to have revealed. Means if ought to have revealed means patent defect, कि मैं वहाँ पे जाके एग्जामिन किया सोफा सेट को और कुछ अगर पेटेंट डिफेक्ट मुझे दिख रहा था, तो आई शैल बी हेल्ड रेस्पॉन्सिबल फॉर इट. मीन्स आई मे नॉट परचेज द सोफा फ्रॉम देयर. फाइन. द शॉपकीपर नीड नॉट बी हेल्ड रेस्पॉन्सिबल फॉर दैट. फाइन. एंड next one, implied warranty or condition as to quality or fitness for a particular purpose may be annexed by usage of trade which is being carried on in that locality or area, and an express warranty or condition does not negative a warranty or condition implied by this act unless inconsistent therewith. Means जो implied, जो express warranty or condition इस act के द्वारा दिया गया, that will be considered unless they have been made inconsistent with the provisions of this act. I hope you all are understanding. See, we need to, since this is a crash course, we need to complete this subject. So we cannot go in very much details. However, जो भी important है वो मैं बता ही रहा हूँ आपको. Now, what are the effects of this contract of sale of goods? Fine. Take a break for 30 seconds, have water and all, then let's resume. Just 20-30 seconds. let's resume. Chapter 3, effects of the contract. This transfer of property, that is transfer of ownership of property from the seller to the buyer. Fine. Goods must be ascertained. Where there is a section 18, where there is a contract of sale of unascertained goods, no property in the goods is transferred to the buyer unless and until the goods are ascertained. Means the goods need to be ascertained. देखो, there is a difference between the word certain and ascertain. This ascertain means capable of being made certain. Capable of being made certain. Fine. So the goods, if they are not certain, then they must be ascertained. Fine. You cannot sell unascertained goods. Fine. Therefore, where there is a contract for sale of unascertained goods, no property in the goods is transferred to the buyer unless and until the goods are ascertained. And the property passage, when intended to pass, means it is transferred to the buyer at such time as the parties to the contract intend it to be transferred. अभी मान लो कि मैं प्रॉपर्टी खरीदता हूँ, मैं दुकान में जाके एक बाइसिकल खरीदता हूँ, फाइन, एंड आई नीड टू गो समवेयर टू परचेस सम अदर आर्टिकल्स. मैं दुकान वाले को पैसे दे देता हूँ, मैं उनको बोलता हूँ कि 2 घंटे बाद आप मैं आके बाइसिकल ले जाऊँगा, है ना. तो देयर इज अ म्यूचुअल कॉन्सेंट बिटवीन वी both of us, between the shopkeeper and myself. Therefore, we may intend that 2 घंटे बाद वो साइकिल की डिलीवरी मैं लूँगा. So there is a contract of sale, and that this contract, such a contract of sale is valid. Fine. For the purpose of ascertaining the intention of the parties, regard shall be had to the terms of the contract, conduct of parties and circumstances of the case. Basically says that mutual consent में जो भी चीज़ें हमें देखनी है वो सारी चीज़ें हम देखते हुए कॉन्ट्रैक्ट पे काम करेंगे, सेल पे काम करेंगे. Unless a different intention appears, the rules contained in section 20 to 24 for rules for ascertaining the intention of the parties as the time at which the property in the goods is to pass to the buyer means 20 से 24 के प्रोविजंस को हम देखेंगे. ये एक बार इसको याद रखना, MCQ में ये पूछता है कि सेक्शन 19 में कौन से प्रोविजंस को रेफर किए गए हैं. तो 20 to 24 में we will see that when the goods are to pass, when they are of deliverable state and all. Section 20, unconditional contract for sale of specific goods in deliverable state. Property in goods passes to the buyer when the contract is made, and it is immaterial whether the time of payment of price or delivery of goods or both is postponed. Goods passes to the buyer when the contract is made and there is an unconditional contract for sale of specific goods. Goods are unidentified. Goods are identified. There are no preconditions attached to the contract of sale. Then there may be a situation that payment of price may be postponed और delivery of goods may be postponed. जो मैंने अभी आपको बताया कि मैं साइकिल छोड़ के गया 2 घंटे बाद ले लूँगा. Fine. The goods passes to the buyer means the ownership passes to the buyer. Fine. Once the contract of sale is executed. Fine. Ownership, goods passage means ownership passes to the buyer. Correct? Specific goods to be put into deliverable state. Contract for sale of specific goods. Seller is bound to do something to the goods for the purpose of putting them into a deliverable state. Property does not pass until such thing is done and the buyer has notice thereof. Now suppose, I'll give you again one example. Suppose you go on to purchase any wooden article. एक टेबल आप खरीदने जा रहे हो वुड का, वुडन, फाइन. नाउ व्हाट द शॉपकीपर डज, उन्होंने आपको टेबल दिखा दिया, फिर वो बोलते हैं कि अब इस टेबल पे पॉलिश होगा, उसके बाद हम आपको भेजेंगे ये टेबल, फाइन. सो अनलेस एंड अनटिल द पॉलिश वाला काम हैज डन, द बायर is not supposed to take the goods, and the seller shall give, or rather the property, rather the ownership shall pass to the buyer once that polish wala kaam has been done. Fine. Specific goods in deliverable state, when the seller has to do anything thereto in order to ascertain price. अब ये देखो, where there is a contract for sale of specific goods in a deliverable state, buyer is bound to take it, but the seller is bound to do weighing, to do weight of the thing, measure or test it or do some other thing in reference to the goods for purpose of ascertaining the price. Property does not pass unless that thing is done and the buyer has noticed thereof. If the seller has to do something, if the seller has to do some weighing of the thing, then the goods cannot be passed. मान लो goods are at deliverable state, buyer is bound to take it, पर उसका वेट पहले करना है, मेजर उसे करना है, उसके बाद वो सेल हो सकता है. Unless and until the buyer does that, the buyer, unless and until the seller does that, the buyer is not bound to take those goods. Fine. Sale of unascertained goods and appropriation. Where there is a contract for sale of unascertained or future goods by description and goods of that description and in a deliverable state are unconditionally appropriated the contract either by seller or with the assent of the buyer or by the buyer with assent of the seller. Property and goods thereupon passes to the buyer if there is assent of both the parties. Such goods are passed to the buyer. Fine. मान लो कोई अनएसर्टेन गुड्स है, फ्यूचर गुड्स है ना, और उसकी डिस्क्रिप्शन दे दी गई है कि इस डिस्क्रिप्शन का है. बायर एग्री कर लिया कि हाँ मैं इसकी ओनरशिप ले लूंगा 4 दिन के बाद जब वो एसर्टेन्ड हो जाएगा, तो सेलर भी एग्री कर लिया कि ओके, देन देयर इज नो इशू. फाइन. द प्रॉपर्टी पासेज टू द बायर. फाइन. सी दे हैव रिटन हियर डिलीवरेबल स्टेट unconditionally appropriated the contract either by seller with the assent of the buyer or buyer with assent of the seller. Property in goods passes to the buyer. Such assent may be expressed or implied or may be given either before or after appropriation is made. अब the next paragraph of section 23 is that which you generally see. आप एक फ्रिज खरीदने के लिए जाते हो तो आप दुकान वाले को पैसे दे देते हो, है ना, और दुकान वाला उस फ्रिज को एक कैरियर से भेजता है, मान लो ऑटो से भेजता है. जैसे ही दुकान वाला उस फ्रिज को उस ऑटो पे दे दिया, रख दिया, है ना, ओनरशिप आपकी है फ्रिज की, दुकान वाले को कोई मतलब नहीं है अब. फाइन. वेयर इन परसुएंस ऑफ द कॉन्ट्रैक्ट द सेलर डिलीवर्स द गुड्स टू द बायर और टू अ कैरियर और अदर बेली फॉर द पर्पस ऑफ ट्रांसमिशन टू द बायर, डज नॉट रिजर्व द राइट ऑफ डिस्पोजल, he is deemed to unconditionally appropriated the goods to the contract. Means he is deemed to perform his duty. Fine. Now the buyer is responsible to anything which occurs with the goods. Fine. Section 24 says that goods sent on approval or on sale or return, देखो, goods sent on approval. When goods are delivered to the buyer on approval or on sale or return or other similar things, property therein passes to the buyer when he signifies his approval or acceptance to the seller and does any other act adopting the transaction. When he signifies his approval or acceptance to the seller or does any other act adopting the transaction, the property therein passage means the ownership passage अभी देखो what happens if you might have seen if you have to buy any ornament, है ना, कोई मान लो गहने खरीदने हैं आपको, तो सपोज आप जा रहे हो तनिष्क में, आप जान ही रहे हो, आप तनिष्क वाले को आप उसके ऐप से कुछ एक ऑर्नामेंट, एक आप ईयरिंग बुक कर रहे हो, फाइन, व्हाट दे डू, वो किसी बंदे को ईयरिंग, आपकी ईयरिंग लेके भेजेंगे, उसके साथ साथ वो 8-10 ईयरिंग लेके और भेजेंगे, है ना. अब दे गिव यू अ चॉइस कि आप जो पहले से उनसे बात कर रहे हो वो आप लोगे या कोई और लोगे, फाइन. वो आपके पास आते हैं, वो आपको दिखाते हैं, दे टेक योर अप्रूवल, once you approve then only that property passes to you, fine, then only you become an owner. Now subsequent to that approval आप उस प्रॉपर्टी को, उसमें ये भी लिखा रहता है कि 15 डेज में आप इसे रिटर्न कर सकते हो. If you do not find it good, then you can return it, fine. So this is what they have said, goods sent on approval or on sale or return, fine. Again, property therein passes to the buyer if he does not signify his approval or acceptance to the seller but retains the goods without giving notice of rejection. Then if a time has been fixed for the return of the goods on the expiration of such time, and if no time has been fixed on the expiration of a reasonable time, means if that person, though he has not given approval, लेकिन वो reject भी नहीं कर रहा है, तो property passes to him, he becomes the owner, the buyer becomes the owner, fine. Reservation of right of disposal, इसमें कुछ खास पढ़ने का नहीं है, क्वेश्चन पूछे भी नहीं है कभी. Risk prima facie passage with the property, this is an important provision. वहाँ पे लिख लो risk follows ownership. Risk follows ownership. Fine. Risk follows property, risk follows ownership. ये भी MCQ में पूछते हैं. Unless otherwise agreed, goods remain at seller's risk unless the property, unless the ownership, ऐसे लिख दो, unless the ownership of property therein is transferred to the buyer. But when the property therein is transferred to the buyer, goods are at buyer's risk whether the delivery has been made or not. जो अभी आप देखें, सामान आपके पास कैरियर से जा रहा है ऑटो से, तो अगर वो आपके पास पहुंचा है या नहीं पहुंचा है उससे फर्क नहीं पड़ता है. एक बार आपको ओनरशिप मिल गई तो देन यू आर टू बी हेल्ड रिस्पॉन्सिबल फॉर इट, प्रोवाइडेड दैट where delivery has been delayed through the fault of either the buyer or seller, goods are at risk of the party in fault as regards any loss which might not have occurred but for such fault. अभी मान लो किसी का फॉल्ट नहीं रहता तो कोई लॉस नहीं होता, लेकिन अगर किसी का फॉल्ट है, मान लो बायर का ही फॉल्ट है, तो he has to bear the loss. सेलर का फॉल्ट है, seller has to bear the loss. And again, provided that nothing in this section shall affect the duties or liabilities of seller or buyer as a bailee of the goods of the other party. मान लो who is a bailee, the person who retains the goods for some specific purpose, he needs to give the goods back to the bailor once that purpose is accomplished. आप ट्रांसफर आप इंडियन कॉन्ट्रैक्ट एक्ट में पढ़े होगे, ठीक है. तो यहाँ पे लिख रहे हैं नथिंग इन दिस सेक्शन शैल अफेक्ट द ड्यूटीज और लाइबिलिटीज ऑफ आइदर सेलर और बायर एज अ बेली ऑफ द गुड्स ऑफ अदर पार्टी. मीन्स अगर मान लो कि आई एम द बेली ऑफ द गुड्स and if any loss has been done to the goods, then I need to suffer that loss. I need to compensate the bailor. Maybe I am a seller, maybe I am a buyer, whoever I am, I need to compensate the real person because I am just the person who is keeping care of the goods. Fine, as a bailee. Fine. Come to section 27. सेक्शन 27 में आप एक मैक्सिम लिखोगे, नेमो डैट क्वाड नॉन हैबिट. Nemo dat quod non habet, that is no person can pass a better title than he himself has. Fine. Subject to the provisions of this act or of any other law for the time being in force, where goods are sold by a person who is not the owner thereof and who does not sell them under the authority or with the consent of the owner, buyer acquires no better title to the goods than the seller had, unless the owner of the goods is by his conduct precluded from denying the seller's authority to sell. Unless the owner is precluded, is prevented, precluded में लिख दो, prevented from denying seller's authority to sell. See, a person who is the owner of a thing has the right to sell the thing. Fine. If he sells the property of someone else, then that someone else who has bought the property gets the similar title as that of this seller. Fine. Because he was not the real owner, this seller was not the real owner, the buyer, the subsequent buyer cannot even be the real owner. Fine. Therefore, there is a rule of nemo dat quod non habet. That is, no person can transfer a better title than he himself has. Fine. This is the general rule. Unless the seller is prevented from denying the title of, or rather unless the owner is prevented from denying the title of this seller, if that owner, for example, has given right to, or rather he has given the power of attorney to sell the object to someone else. Fine, he has given the power of attorney to the seller. Then the seller can sell the property. This owner cannot deny the selling of the property by this seller. Fine. So therefore they have written in the last part, unless the owner of the goods is by his conduct precluded from denying the seller's authority to sell. However, that is provided that where a mercantile agent is with the consent of the owner in possession of the goods or of a document of title to the goods, any sale made by him when acting in the ordinary course of business of a mercantile agent shall be as valid as if he were expressly authorized by the owner of the goods to make the same, provided that the buyer acts in good faith and has not at the time of the contract of sale noticed that the seller had not authority of sale. Mercantile agent. Fine. Mercantile agent is a person who acts as an agent of the principal in the course of the business. Fine. Now, mercantile agent, if he sells anything to someone else, to the buyer, and the buyer does not have any such doubt that this mercantile agent cannot sell this property, fine, then the buyer can take the property very much validly, and the owner of the property cannot question this mercantile agent, because this mercantile agent is the agent of that principal only, and knowledge to the agent is knowledge, rather notice to the agent is notice to the principal. Notice to the agent is notice to the principal. We have one legal maxim. Any idea? Any idea of that legal maxim? Qui facit per alium facit per se. Fine. So this agent, mercantile agent, has the right to sell the commodity. The real principal cannot question his right, because he had himself given him the right, and the buyer, if he had no such notice that this real agent, this mercantile agent cannot sell the property, then this buyer becomes a true owner of the property. Fine. Sale by one joint owners person in possession under voidable contract, ये सब कभी पूछे नहीं हैं, है ना. ऐसे कॉन्ट्रैक्ट जब आप पढ़ोगे तो ये आप याद रखना, ठीक है. सेक्शन 14 to 21 इनफैक्ट याद रखना. एक कुछ सेक्शंस लिख लो. तो ये जो सेक्शन 27 में है ना, नेमो डैट क्वाड नॉन हैबिट, जनरल रूल इज नेमो डैट क्वाड नॉन हैबिट, फाइन. फॉर ट्रांसफर प्रॉपर्टी एक्ट नो पर्सन कैन पास अ बेटर टाइटल देन हिमसेल्फ हैज, लेकिन मर्केंटाइल एजेंट तो सेल कर रहे हैं, है ना. तो उसी तरह से और भी एक्सेप्शंस लिख लो नेमो डैट क्वाड नॉन हैबिट का, जो इस एक्ट में है और जो इंडियन कॉन्ट्रैक्ट एक्ट में भी है, ठीक है. 5-6 एक्सेप्शंस लिख लो. लिखो सेक्शन 27 is one exception इस एक्ट में. Then the proviso to section 27 is another exception. Then come to section 28. एक बार देख ही लो. Section 28 is another exception. If one of several joint owners of goods has the sole possession of them by permission of co-owners, property in goods is transferred to any person who buys them in of such joint owner in good faith and has not at the time of contract of sale noticed that the seller has not authority to sell, है ना. तो ये भी it will be a good sale. Then 29, sale by person in possession under voidable contract. Contract has not been rescinded at the time of sale. Buyer acquires good title provided he buys them in good faith and without notice of seller's defect of title. Fine. Again, the next exception is section 30 का clause 1 of section 30, where a person having sold goods continues or is in possession of the goods or of documents of title, delivery or transfer by that person or by a mercantile agent acting for him of the goods or documents of title under any sale, pledge or other disposition thereof to any person receiving the same in good faith and without notice of the previous sale, shall have the same effect as if the person making the delivery or transfer were expressly authorized by the owner of the goods to make the same. Section 30 का clause 1 of section 30 is again an exception. Then even the second clause, section 30 clause 2, where a person having bought or agreed to buy goods obtains with the consent of the seller possession of the goods or documents of title to the goods, the delivery or transfer by that person or by a mercantile agent acting for him of the goods or documents of title under any sale, pledge or other disposition thereof to any person receiving the same in good faith and without notice of any lien or of the right of original owner in respect of the good, shall have effect as if such lien did not exist. Fine. Again, this is an exception. Then again you have section 54 clause 3. एक बार 54 देख लो. फिर वापस आ जाएंगे हम लोग 30 पे। Where an unpaid seller who has exercised his right to lien or stoppage in transit resells his good, buyer acquires a good title there to edge against the original buyer in spite of the fact, notwithstanding that no notice of the resale has been given to the original buyer. देखो एक original buyer है जो सामान खरीद लिया, वो पैसे नहीं दिया, तो this seller who had the custody of the goods, he has the right to lien over the goods, or he can stop the goods in transit. Fine. Once suppose he has right to lien, he has retained the goods, he can sell it to another someone else. No issue that the notice of such subsequent sale was not given to the initial buyer. Fine. बट एक बार जब वो प्रॉपर्टी सेल कर दिए थे, भले उन्हें पैसे नहीं मिले थे, सेल तो वो कर दिए थे, है ना, तो दैट न्यू बायर बिकेम द ओनर ऑफ द प्रॉपर्टी, बट अगेन दिस सेलर इज हिमसेल्फ सेलिंग द प्रॉपर्टी because the price was not paid. So he was not an owner, but he was selling the property. Nemo dat quod non habet. He cannot sell that property, but he is selling. This is an exception to nemo dat quod non habet because his rights were impaired. He did not get the amount of the commodity. Therefore, he is selling. Fine, to someone else. Again, write another exception. ये तो 54 का क्लॉज 3 लिखे थे. अब इंडियन कॉन्ट्रैक्ट एक्ट में 169 फाइंडर ऑफ गुड्स. देखो, there is a general duty of the finder of goods to find the person and give him the goods. However, if he cannot be found after reasonable search and 2/3 of the value अगर उसका depreciate कर गया, तो he can sell the property. Fine, so he is not the owner, but still he can sell the property. Again, after 169, one last one, section 176 of Indian Contract Act. 176 में the pawnee, the bailee can sell the goods if the payment is not made by the pawner. मतलब जो pledge किया था उसने अगर पैसे नहीं दिए हैं, तो this person, the pawnee, जो बेली होता है जिसे हम pawnee बोलते हैं pledge में, he can sell the goods. Fine. Come to section 31 now. Let's again take a water break for 10 seconds. Come to section 31. Duties of seller and buyer. It is the duty of the seller. It is the duty of the seller है, to the seller लिखा हुआ है. It is the duty of the seller to deliver the goods and of the buyer to accept and pay for them in accordance with the terms of contract of sale. It is the duty of the seller to deliver the goods. Now, how this delivery can be made? This delivery can either be actual delivery, this delivery can either be symbolic delivery, or this delivery can be constructive delivery. Fine. Actual delivery. Actual delivery. You go to purchase a car, you get the keys, real keys of the car. Actual delivery, you have got the delivery of the car, you have got the ownership of the car. Symbolic delivery. You go to purchase a car, you have got the car, you have paid the price, but since the registration number was not allotted to you yet, so the showroom person do not give you the actual delivery of the car, though you are the owner, but for the purpose of clicking of the photographs, they give you this long size key, चाबी, और ये पकड़ के पिक्चर क्लिक करवाते हैं, देखे हो, है ना? दिस इज सिंबॉलिक डिलीवरी. आप एक वेयर हाउस में कोई सामान रखा हुआ है किसी का, सेलर का, यू इंटेंड टू बाई दोज कमोडिटीज, फाइन. The seller gives you time that you can get those goods transferred at your place in 10 days. Fine, you can get a go down and transfer them in 10 days. Meanwhile, you take the keys of the warehouse once you have paid the price, once you have purchased those goods. Fine. This is constructive delivery. Constructive. So this delivery can be of 3 types. Fine. And payment and delivery are concurrent conditions unless otherwise agreed. They are concurrent conditions. That is, एक साथ दोनों होना है. One shall be ready to give you the commodity. You shall be ready to give him the price. Fine. This is concurrent condition. C. Willing to give the possession of the goods to the buyer in exchange of the price. Buyer shall be ready and willing to pay the price in exchange of possession of the goods. And delivery of goods sold may be by doing anything which the parties agree shall be treated as delivery, or which has effect of putting the goods in possession of the buyer or of any such person authorized to hold on his behalf. This any such person is the agent of the buyer. Fine. Even if it is given to the agent, it constitutes delivery of property. Effect of part delivery. In progress of the delivery, if partly the object has been delivered, it has the same effect as the delivery of the whole, but a delivery of the goods, a delivery of part of goods with an intention of severing it from the whole does not operate as a delivery of the remainder. मान लो 2 सिचुएशन है. एक सिचुएशन है कि आपको गुड्स डिलीवर करना है, 10 किलो चावल डिलीवर करना है, 5 किलो आप अभी कर देते हो, है ना? आप बाइक से डिलीवर करने जा रहे हो, पीछे एक बंदा पकड़ के बैठा हुआ है, 5 किलो अभी ले जा रहा है, 5 किलो 10 मिनट के बाद आके दे देगा. तो इट ऑपरेट्स एट डिलीवरी ऑफ द फुल क्वांटिटी. बट अगर मान लो 10 किलो के गनी बैग से आपको 5 किलो निकाल के ही सिर्फ डिलीवर करना है, तो पार्टली डिलीवरी हो रहा है. दैट डज नॉट ऑपरेट एज डिलीवरी ऑफ द फुल amount of that chawal. If there is an intention of severing it, removing it from the whole gunny bag. Fine. Buyer to apply for delivery. Apart from any express contract, seller of the goods is not bound to delivery until the buyer applies for delivery. Means the buyer has to tell that he needs the commodity, then only the seller is bound to deliver the commodity. Fine. Now 36 rules of delivery and all. 37 डिलीवरी ऑफ रॉन्ग क्वांटिटी. ये एक बार क्वेश्चन में पूछा गया है, डिलीवरी ऑफ रॉन्ग क्वांटिटी किस प्रोविजन में दिया गया, इसलिए बस एक 37 याद रखना. Fine. Then installment by deliveries. Buyer of the goods is not bound to accept delivery thereof by installments, otherwise unless otherwise agreed. मतलब अगर agree both have consented that delivery हो सकती है installment में, then it can be in installment. Otherwise it cannot be in installment. Fine. Then 39 and all, एक बार देख लेना, इससे क्वेश्चन तो कभी पूछे नहीं है. देखो एक 41 पूछते हैं ये लोग. 41 देखो, buyer's right of examining the goods. If the buyer has not previously examined the goods, he is not deemed to have accepted them unless and until he has a reasonable opportunity of examining them for the purpose of ascertaining whether they are in conformity with the contract. Means the buyer shall get reasonable opportunity of examining the goods. Fine. इसीलिए आप देखते हो अभी जो मैं आपको ओपन बॉक्स डिलीवरी की बात बता रहा था ऑनलाइन प्लेटफॉर्म्स में, है ना, यही ये ओपन बॉक्स डिलीवरी वाला प्रोविजन है. फाइन. द बायर इफ ही हैज नॉट एग्जामिन्ड द गुड्स, ऐसा नहीं है कि आपको वो कोरियर वाला सामान देके चले. आप देखो आजकल बहुत सारे ऐसे केसेज हो रहे हैं, वो आईफोन कोई मंगाता है और अंदर से वो ब्रिक निकलता है. फाइन. तो देयरफॉर ये एग्जामिनिंग द गुड्स ओपन बॉक्स डिलीवरी का कॉन्सेप्ट आ गया. फाइन. So the buyer shall have reasonable opportunity of examining the goods. Fine. It does not mean that once he has taken the goods, he cannot do anything. Fine. He still has the right. Fine. So this is in section 41, and then 42 is acceptance. 43, 44 ये सब एक बार देख लेना, कुछ ऐसा है नहीं. 45 में आओ जो इम्पोर्टेंट है. Unpaid seller. Unpaid seller. Who is an unpaid seller? An unpaid seller is the seller of the goods who has not got the whole of the price, or in the case of a bill of exchange or other negotiable instrument, it has been received as conditional payment and the condition on which it was received has not been fulfilled by reason of dishonor of the instrument. See, if the whole price is not paid to the seller, he is an unpaid seller. Fine. यहाँ कोई दिक्कत नहीं है. बिल ऑफ एक्सचेंज की जहां बात आती है ये है, या दूसरे नेगोशिएबल इंस्ट्रूमेंट की बात आती है. अगर मान लो किसी नेगोशिएबल इंस्ट्रूमेंट को पार्ट पेमेंट के लिए लिया गया है ना, और जो बाकी पेमेंट है उसमें वो नेगोशिएबल इंस्ट्रूमेंट डिसऑनर हो गया. फाइन. सो द अमाउंट मेंशन इन दैट नेगोशिएबल इंस्ट्रूमेंट कैनॉट बी गिवन टू द ड्रॉई. फाइन. वंस दैट अमाउंट कैनॉट बी गिवन, then also that seller will be considered an unpaid seller. Fine. So in these two situations he can be called an unpaid seller. और जो क्लॉज 2 है इसमें इंपॉर्टेंट लिख लो, ये MCQ पूछे हैं. Seller includes any person who is in the position of a seller and an agent of the seller. Agent of the seller ये पूछा गया है. Agent of the seller. Seller includes agent of the seller. Fine. Next one, you have rights of unpaid seller. Unpaid seller's rights subject to the provisions of this act. देखो सेक्शन 46 में और सेक्शन 47 में दोनों जगह राइट्स दिए हुए हैं. ठीक है. सेक्शन 46 में they have given 3 kinds of rights of the unpaid seller. पहला, the first one is the seller has a lien on the goods for the price while he is in possession of them. Lien. Second, in the case of insolvency of the buyer, a right of stopping the goods in transit after he has parted with the possession of the goods. Third, right of resale as limited by this act. लिखो इसको. Unpaid seller has 3 rights: right to lien, right to stoppage in transit, right to resale. अब again just 1 minute. Right to lien, right to stoppage in transit, right to resale. इन तीनों में राइट टू लियन व्हेन, अब एक ऑप्शन अगर आपको एक क्वेश्चन ऐसा दे दे, राइट टू लियन कब होगा, ऑप्शन 1 है सेलर इन पोजेशन ऑफ द गुड्स, सेकंड है बायर इंसॉल्वेंट, थर्ड है एज लिमिटेड बाय दिस एक्ट, फोर्थ है ऑल ऑफ द अबव, ऑल द अबव. और आपका क्वेश्चन दिया हुआ है चूज द मोस्ट एप्रोप्रिएट रेस्पॉन्स. फाइन. द मोस्ट एप्रोप्रिएट रेस्पॉन्स इज लियन तभी होगा जब सेलर के पोजेशन में रहेगा. गुड्स इन पोजेशन ऑफ सेलर. स्टॉपेज इन ट्रांजिट तभी होगा जब बायर हैज बिकम इनसॉल्वेंट, एंड रीसेल तभी होगा एज mentioned in this act. Got the point? Got the point? Now tell me, what is this lien? What is this lien? Lien, remember always, it is not the right to acquire the goods. Rather, it is a right to continue in the possession of the goods. Fine? It is not the right to acquire the goods. अब मान लो, suppose the buyer has taken the possession of the goods. He has told you that he shall be paying you the amount once he reaches his home. Fine, अभी उसके मोबाइल में नेटवर्क नहीं आ रहा है, वो घर पहुंच के आपको पैसे दे देगा 2000 रुपये. 10,000 का गुड्स था, 8,000 दिया है, 2,000 रुपये बोला घर पहुंच के दे देगा. अभी मोबाइल में नेटवर्क नहीं आ रहा है, ऑनलाइन पेमेंट करनी है ना. एंड ही गोज होम, ही रीचेज होम, 10 दिन तक पैसे ही नहीं दिया और बोलता है अब तो मैं नहीं दूंगा. तो क्या करेगा सेलर डज नॉट हैव द राइट टू रिटेन द गुड्स. रिटेन कब करेगा? जब उसके पास गुड्स रहते तभी ना. ही डज नॉट हैव द राइट टू हैव लियन ओवर द गुड्स. लियन इज नथिंग बट कंटिन्यूइंग इन द पोजेशन ऑफ द गुड्स, रिटेनिंग द गुड्स. द सेलर नाउ कैनॉट रिटेन द गुड्स. द सेलर कैन फाइल अ सिविल सूट अगेंस्ट दैट बायर. फाइन, दिस इज द ओनली रेमेडी लेफ्ट विद द सेलर. फाइन, देयरफॉर राइट टू लियन तभी होता है जब द सेलर हैज द पोजेशन ऑफ द गुड्स विथ हिमसेल्फ. Fine. Come to 47. 47 में एक बार इसका 46 का क्लॉज 2 देख लो पहले. Where the property in goods has not passed to the buyer, means where the ownership has not passed to the buyer, unpaid seller has, in addition to his other remedies, a right of withholding delivery similar to and coextensive with the rights of lien and stoppage in transit where the property has passed to the buyer. Means अगर वो घर चला गया बंदा, गुड्स लेके चला गया, तब तो सिविल सूट करेगा. अगर गुड्स बोला कि ठीक है मैं भेज दे रहा हूँ आपको, और वो बंदा भी पैसे नहीं दिया, बोला कि अब तो मैं नहीं दे पा रहा हूँ, तो स्टॉपेज इन ट्रांजिट रोक लेगा, गुड्स को नहीं जाने देगा, है ना. दो ओनरशिप हैज ट्रांसफर टू द बायर, स्टिल द सेलर हैज द राइट टू हैव द स्टॉपेज इन द ट्रांसिट. फाइन. And if the properties have not been passed to the buyer, if the ownership has not been passed to the buyer, unpaid seller has other remedies, in addition to other remedies, right of withholding delivery. Means वो भेजेगा ही नहीं सामान, है ना, वो withhold कर लेगा डिलीवरी को. एंड सेलर्स लियन, अब जो हम लियन की बात कर रहे थे, जो सेलर अपने पोजेशन में गुड्स रखा हुआ है उस पर वो जो लियन कर रहा था, वो एक बार आप देख लो. सेलर्स लियन सब्जेक्ट टू द प्रोविजंस ऑफ दिस एक्ट, द अनपेड सेलर ऑफ द गुड्स who is in possession of them is entitled to retain possession of them until payment or tender of the price in the following cases, namely where the goods have been sold without any stipulation to credit. Without any stipulation to credit. अगर मान लो कुछ ऐसी बात नहीं की गई है कि क्रेडिट पे गुड्स जा रहे हैं, तो द सेलर हैज द राइट टू लियन ऑन दैट प्रॉपर्टी, ऑन द गुड्स. और where the goods have been sold on credit but the term of credit has been expired. अगर मान लो है कि 2 महीने में पैसे, क्रेडिट मतलब हमेशा क्रेडिट कार्ड थोड़ी होता है, क्रेडिट मतलब लोन, ठीक है, बाद में पैसे देंगे. तो मान लो वो है कि 2 महीने में पैसे दे देंगे, और 2 महीने में पैसे नहीं देता है, if he does not give पैसे money within 2 months, तो he can have the right to lien over the goods, है ना. और where the buyer becomes insolvent, he has the right to lien if the goods have not been passed to the buyer yet. Means he has the right to, is entitled to retain possession. This retaining of possession is nothing but right to lien. Seller may exercise his right to lien in spite that he is in possession of the goods as agent or bailey of the buyer. अब मान लो बायर कहीं बेली के रूप में वो सेलर है, बायर ही पैसे नहीं दे रहा है ना, तो ठीक है, he can retain the goods as lien. Fine. 48 is part delivery, where an unpaid seller has made part delivery of the goods, may exercise his lien on the remainder unless such part delivery has been made under such circumstances as to show an agreement to waive the lien. अगर मान लो पार्ट डिलीवरी किया है, पैसे नहीं मिल रहे हैं, तो राइट टू लियन है जो बाकी प्रॉपर्टी बची हुई है. लेकिन अगर कुछ कॉन्ट्रैक्ट है कि राइट टू लियन नहीं कर सकता है, देयर इज अ कॉन्ट्रैक्ट टू दिस, fine, between the buyer and the seller, then he cannot even have the lien over the property. He needs to give it to the person, and if that person, if the buyer does not pay even the money to him within the time, then this person may file a suit against him. Fine. 49 याद रखना. देखो 46, 47, 46 याद रखना. पहले तो देखो एक बार ये देखो पहले 46 deals with all the rights of unpaid seller. 47 only deals with right to lien. Fine. एकदम याद रखना. 46 all the rights. 47 only lien. Fine. 48 part delivery. Now come to 49 termination of lien. The unpaid seller of goods loses his right to lien when his right to retain the goods is lost. When he delivers the goods to a carrier or other bailey for the purpose of transmission to the buyer without reserving the right of disposal of the goods, जब वो किसी कैरियर को दे देता है, अपने पास राइट टू डिस्पोज ऑफ द गुड्स, डिस्पोज द गुड्स नहीं रखता है, तो बाय द बायर और हिज एजेंट लॉफुली ऑब्टेन्स द पोजेशन ऑफ द गुड्स, बायर या उसके एजेंट अगर पोजेशन ले लिए लॉफुली, तब तो दिस पर्सन हैज ओनली द राइट टू फाइल अ सूट, फाइन. एंड बाय वेवर देयरऑफ this unpaid seller has himself waived his right to retain the goods. In the contract they have mentioned a clause that this unpaid seller cannot retain the goods, he cannot have lien over the goods. So fine, he cannot have. And unpaid seller of goods having lien thereof does not lose his right by reason only that he has obtained a decree for the price of the goods. अगर मान लो right to lien was there, fine, he has filed a suit for price of the goods. Now the price of the goods has been obtained to him, has been obtained by him. Still, he can have the right to lien over the goods unless and until he gets an order from the court to give that good, to give those goods to the real buyer. Fine. Right of stoppage is in transit. ये बस सेक्शन नंबर याद रखना 50 में है, ठीक है. He seller has parted with the possession of the goods. He has the right to stop them in transit. That is, he may resume possession of the goods as long as they are in the course of transit, may retain them unless until payment or tender of price. Fine. 50 stoppage in transit याद रखना. 51 कुछ वैसा है नहीं. 55 में आओ. 51, 52 सब कुछ खास नहीं है. देखो मैं बोल रहा हूँ खास नहीं है मतलब पूछते नहीं है क्वेश्चन, बाकी एक बार पढ़ जरूर लेना. डू नॉट लीव एनी क्वेश्चन, आई मीन डू नॉट लीव एनी प्रोविजन, डू नॉट लीव. फाइन, ठीक है. मतलब 90% चांस है नहीं पूछेंगे, लेकिन 10% में अगर पूछ लिए, ठीक है, तो डू नॉट लीव. और मैं भी अगर छोड़ रहा हूं तो हार्डली ये 66 में 10 प्रोविजन छोड़ूंगा, हार्डली. वो पढ़ लेना. सूट फॉर प्राइस जो अभी हम बात कर रहे थे, ये क्वेश्चन पूछा भी गया है, इसको लिख लेना. Where under a contract of sale the property in the goods has passed to the buyer and the buyer wrongfully neglects or refuses to pay for the goods according to the term of the contract, the seller may sue them for price of the goods and and where in the contract of sale the price is payable on a day certain irrespective of delivery, buyer wrongfully neglects or refuses to pay the price, seller may sue him for price although the property in the goods has not passed, the goods have not been appropriated by the contract. अगर किसी एक पर्टिकुलर दिन पे पैसे देने थे और वो नहीं दिया तो सेलर में sue him. फाइन. (56, 57) डैमेजेज फॉर नॉन एक्सेप्टेंस नॉन पेमेंट. देखो अगर बायर गलती करता है तो सेलर में sue him नॉन एक्सेप्टेंस में, और सेलर गलती करता है तो बायर में sue him 57 में. फाइन. डैमेजेस फॉर नॉन डिलीवरी, सेलर मान लो डिलीवरी नहीं देता तो बायर में क्लेम कॉम्पनसेशन फ्रॉम हिम. और नॉन एक्सेप्टेंस 56 में अगर बायर अगर रॉन्गफुली डिलीवरी करता है पैसे देने के लिए तो सेलर में sue him फॉर डैमेजेस कॉम्पनसेशन. फाइन. 58 याद रखना. 58 में ये आपसे पूछ सकता है कि कौन सा प्रोविजन स्पेसिफिक रिलीफ एक्ट के कॉरेस्पॉन्डिंग है. फाइन. तो 58 सेक्शन 58. फाइन. ठीक है. अब आ जाओ नीचे, ये सब देख लेना एक बार. रेमेडी फॉर ब्रीच ऑफ वारंटी सब देख लेना. नीचे स्क्रॉल करो, ये है 60 देख लोगे, 61, 62, 63 एक बार बस याद रखना जो पहले भी आपने देखा है. रीजनेबल टाइम क्या है? इट इज अ क्वेश्चन ऑफ फैक्ट. अब आओ एक क्वेश्चन 64, इसको ये पूछा गया है. व्हाट इज दिस ऑक्शन सेल? ऑक्शन सेल, ऑक्शन नीलामी. नीलामी. मुझे एक चीज बताओ, दिस ऑक्शन सेल इज एन ऑफर और एन इन्विटेशन टू ऑफर, प्रपोजल और एन इन्विटेशन टू प्रपोजल? ऑक्शन सेल इज एन इन्विटेशन टू प्रपोजल. फाइन. उसी ऑक्शन सेल में जब बिडिंग होती है 10,001, 10,502, दिस बिडिंग इज एन ऑफर और इन्विटेशन टू ऑफर. This is an offer. Auction sale is an invitation to offer. This bidding is an offer. एक चीज हमेशा याद रखना कि जो ऑक्शनियर है, he is not bound to accept the highest price, and even he can sit as a bidder. He can even bid because उन्होंने एक प्राइस रखा है 20,000 रुपये. अब मान लो अगर 20,000 तक कोई पहुंच ही नहीं पा रहा है, तब तो उसे सेल करना होगा ना 15,000 में. मान लो 15,000 लास्ट आया है ना, तो he sits as a bidder himself, and he can also bid, or if he wants, he will not be selling at the highest price also. Fine. Come to auction sale. In a case of a sale by auction, where the goods are put up for sale in lots, each lot is prima facie deemed to be subject of a separate contract of sale, and the sale is complete when the auctioneer announces its completion by the fall of hammer or in other customary manner. Until such announcement is made, any bidder may retract his bid. मतलब वो अपने बिड से वापस जा सकते हैं जब तक वो हथौड़ा नहीं, फॉल ऑफ हैमर नहीं होता, या कोई दूसरा अगर कस्टमरी मीन्स है तो उसके अकॉर्डिंग वो हाईएस्ट बिड को एक्सेप्ट नहीं करते हैं. तब तक एनी पर्सन हु हैज मेड द बिड, ही कैन रिट्रैक्ट, ही कैन गो बैक फ्रॉम हिज बिड. फाइन. Third, a right to bid may be reserved expressly by or on behalf of the seller. Fine. Means this seller can have a right to reserve his own say. His own say. Means he can have the final word with him. Suppose he does not get a price, then he can bid himself so that he shall not be compelled to give the commodity to the highest bidder. Fine. And section clause 6, if the seller makes use of a pretended bidding to raise the price, the sale is voidable at the option of the buyer. अब बहुत बार क्या होता है ना कि जो सेलर होते हैं ना, जो ऑक्शनियर होते हैं, वो अपने दो एजेंट को भी बैठा देंगे. ठीक है, वो बोलेगा 10,001, लास्ट में हो गया खत्म 10,010 तक, तो एजेंट बोल देगा 10,015, 10,015, है ना. तो अगर ये प्रिटेंडेड बिडिंग हो रहा है और अगर इसकी एविडेंस मिल गई, मान लो वो पकड़ा गया कि उनका खुद का आदमी है, तो दिस बायर, दिस जो हाईएस्ट बिडिंग वाला बायर है ना, दिस बायर ही कैन अवॉइड द कॉन्ट्रैक्ट. फाइन. इट इज वॉइडेबल एट द ऑप्शन ऑफ दिस बायर. फाइन. देन यू हैव (64A) में टैक्सेज की बात बोल रहा है, जरूरत नहीं है कुछ उसमें खास पढ़ने की. 65 रिपील. 66 इज सेविंग्स. फाइन. ये एक बार देख लेना बस. एंड वी आर डन विथ द सेल ऑफ गुड्स एक्ट. दो इट वॉज अ हरक्यूलियन टास्क टू कंप्लीट इट इन 2 hours, स्टिल एनी हाउ आई मैनेज्ड टू कंप्लीट इट, though I did not leave any important provision. Almost everything was covered. Now come to MCQs. Take a 10-15 seconds break, have water, and then we shall be doing MCQ. चलो, come to MCQs. The Sale of Goods Act 1930 came into force on Sale of Goods Act 1930 came into force on 1st July 1930. आपने पढ़ा है अभी. Goods within the meaning of section 2 clause 7. Goods within the meaning of, चलो मैं टिक नहीं करूंगा क्योंकि वो नीचे में फिर आ जाएगा टिक. Goods within the meaning of section 2 clause 7 of the Sale of Goods Act. Actionable claim होते हैं गुड्स, मनी होते हैं गुड्स, नहीं होते हैं, नाइदर ए नॉर बी. फाइन. यहीं पे अगर स्टॉक्स रहता, स्टॉक्स वुड हैव बीन गुड्स. गुड्स में क्या क्या होते फिर? गुड्स में देयर वुड हैव बीन एनी मूवेबल प्रॉपर्टी, stocks, shares, grass, any immovable property agreed to be severed, before contract of sale, then growing crops, these all would have been goods. Correct? Chalo. Sale of goods 1930 deals with what? Movable goods, immovable goods, what? Movable goods. देखो क्वेश्चंस कितने इजी हैं, मतलब एक बार बैरक देखने के बाद क्वेश्चन सीम टू बी वेरी इजी. नहीं, मूवेबल गुड्स. विच ऑफ द फॉलोइंग इज नॉट इंक्लूडेड इन द डेफिनेशन ऑफ गुड्स? एक्शनेबल क्लेम्स डज नॉट आर नॉट इंक्लूडेड. ग्रोइंग क्रॉप्स आर गुड्स, ग्रास आर गुड्स, मूवेबल प्रॉपर्टीज आर गुड्स. सेक्शन 2 क्लॉज 7 अगेन गुड्स वाले. इंक्लूड्स, मूवेबल इमूवेबल तो इंक्लूड नहीं करते हैं. एवरी काइंड ऑफ इमूवेबल प्रॉपर्टी इंक्लूड नहीं होता है. एवरी काइंड, ऑप्शन सी, एवरी काइंड ऑफ मूवेबल प्रॉपर्टी अदर देन एक्सेप्टेबल क्लेम्स एंड मनी. फाइन. ऑप्शन डी में देखो इंक्लूडिंग मनी लिख दिए हैं, तो दे आर नॉट गुड्स, मनी आर नॉट गुड्स. A sale of goods, question 6, sale of goods creates, अब बताओ मुझे, ये ऑप्शन सी इज करेक्ट, बोथ ए एंड बी. A is right in rem and B is right in personam. Now tell me, how does this sale of goods create both right in rem and right in personam? If you try to remember section 4, sale, fine. What is section 4? Come to section 4. देखो, सेक्शन 4 जो हेडिंग है 4 के पहले, दैट इज कॉन्ट्रैक्ट ऑफ सेल. दिस कॉन्ट्रैक्ट ऑफ सेल इज अ कॉन्ट्रैक्ट वेयर बाई द सेलर ट्रांसफर्स और एग्रीज टू ट्रांसफर. नाउ वेयर बाई दिस सेलर, if this seller transfers, this is a sale. If he agrees to transfer, this is an agreement to sell. Fine. This sale is a right in rem and this agreement to sell is a right in personam. Therefore, come to the question. Come to the question. Sale of goods. Fine. Right in rem जो sale हुआ, right in personam जो agreement to sell हुआ, है ना? Again I am telling you, दिस इज एग्रीमेंट टू सेल, हमेशा याद रखना सेल है, SELL, नॉट, फिर से लिख दे रहा हूं, एग्रीमेंट टू सेल, ये गलत है, ठीक है, SALE नहीं। नेक्स्ट, which of the following are goods within the meaning of section 2 clause 7? Things attached to land which are agreed to be severed before sale, fine, goods, movable property. Things forming part of land agreed to be separated before sale, fine, movable property. So either A or B, both are, in fact इसमें ऑप्शन both A and B होना चाहिए था, लेकिन ये जहाँ BJS में, बिहार जुडिशियल सर्विस में पूछा है, either लिखा है, तो फाइन, ओके, नो इश्यूज। फ्यूचर गुड्स कहां डिफाइन किया गया है? 2 clause 6 फ्यूचर गुड्स, गुड्स 7 है, FG, गुड्स 7 अल्फाबेटिकल है, गुड्स 7, फ्यूचर गुड्स 6, 2 clause 6। डिलीवरी, डिलीवरी मीन्स आपने पढ़ा है ट्रांसफर ऑफ पोजेशन फ्रॉम वन पर्सन टू अनदर एंड वॉलेंटरी ट्रांसफर ऑफ ओनरशिप। मैंने उसमें बताया था ना, वहां पे लिखा हुआ था प्रॉपर्टी, मैंने आपको बताया था दो चीज, या तो मेन पार्ट है प्रॉपर्टी, दैट इज ट्रांसफर ऑफ प्रॉपर्टी, उसके साथ एंसिलरी पोजेशन या यूजिंग द प्रॉपर्टी, फाइन। सो बोथ जनरल एंड स्पेशल प्रॉपर्टी इज known as delivery for the purpose of transfer of property, for the purpose of sale of goods act, fine। वॉलेंटरी ट्रांसफर ऑफ व्हाट? देखो डेफिनेशन, देखो देखो डेफिनेशन, लेट्स सी द डेफिनेशन वंस। It is voluntary transfer of possession from one person to another, fine। So transfer of possession from one person to another and voluntary transfer of ownership लिखा हुआ है। चलो अगर मान लो, क्योंकि वो पंजाब में जो आंसर की आया था उसमें ऑप्शन बोथ A एंड B लिखा है, लेकिन चलो आप एक काम करो, वो अगर ये लिखोगे तो यहाँ पे फिर पोजेशन होना चाहिए, ओनरशिप होगा ही नहीं, ठीक है, फाइन। चलो नेक्स्ट, 2 clause 6 अगेन क्या है? फ्यूचर गुड्स नॉट इन एग्जिस्टेंस, goods which are not in existence. Then delivery can be actual, symbolic, constructive. Then property 2 clause 11, general property, not correct in making distinction between sale and agreement to sell. देखो not correct, correct वाला पहले देखो। A sale affects a transfer of general property in goods to the buyer, but the agreement to sell gives to either party a remedy for any default in fulfilling this part of the agreement to sell, correct? Option C एक बार देख लो, in sale the goods, if the goods are destroyed, loss unless otherwise agreed falls on the buyer, क्योंकि sale हो चुका है। However, in agreement to sell, if the goods are destroyed, the loss unless otherwise agreed falls on the seller, because यहाँ पे सिर्फ agreement to sell हुआ है, right in personam है, goods have not passed to the buyer, fine। Now the third, नहीं ये हमने D पढ़ा था, C एक बार आ जाओ। C में in sale if the buyer fails to pay for the goods, the seller may sue for the price, but in agreement to sell, sale में ठीक है पैसा नहीं देगा तो he can sue him for the price, but in agreement to sell, seller can sue only for damages if the buyer fails to accept or pay for the goods, fine। correct है? incorrect में आ जाओ, option B, sale creates just in personam, मतलब right and just, जब आप हॉफेल चार्ट देखोगे jurisprudence में तो right and just are the same thing, fine। तो a sale creates a just in personam, whereas an agreement to sell creates a just in rem, but they shall be opposite। Sale creates right in rem, agreement to sell between two persons. There is merely an agreement, therefore it creates a right in personam. Fine, correct. Again, contract is called sale. Option B, where the property is transferred from the seller to the buyer. जहां पे agreed है, ऑप्शन ए में agreed है, it will be agreement to sell. Fine. This is agreement to sell. Fine. Option A वाला. This is agreement to sell. Next, section 9. What is section 9? Ascertainment of price. Section 10, valuation. 11, stipulation. 12, condition and warranty. Fine. 13, when condition can be treated as warranty. Fine. 16, maxim. Caveat emptor. 27, maxim. Nemo dat quod non habet. 16, where the price of the goods under contract of sale is to be fixed by valuation of a third party who fails to fix the valuation, but the goods are supplied to the buyer under section 10, the buyer shall pay a reasonable price. Correct? Liable to pay the reasonable price of the goods. Then again, contract. Then a warranty is a stipulation in the contract which is collateral to the main purpose and breach of it gives rise to a claim for damages. देखो दो जगह आपको पता है कि वारंटी कोलैटरल है. अब कोलैटरल का दो ऑप्शन है, एक ये वाला, बी, एक डी. बी में है कोलैटरल टू द मेन पर्पस ऑफ द कॉन्ट्रैक्ट, डी में है कोलैटरल टू द मेन पर्पस ऑफ कॉन्ट्रैक्ट. नो इश्यूज. नेक्स्ट पार्ट बी में विदाउट राइट टू क्लेम डैमेजेज इन केस ऑफ ब्रीच ऑफ इट, but the person has the right to claim damages in the case of a breach of warranty. Therefore option D is, and breach of it gives rise to claim for damages. Fine. So condition is such a warranty is such a stipulation which if breached gives rise to claim of damages. Fine. Claim for damages. And in the case of breach of condition, the whole contract can be avoided. Fine, because it is something essential to the part of the contract. Fine. In a contract for sale of specific goods, if at the time of the contract the goods have without the knowledge of the seller perished, then the contract is void for both the parties. Fine. Implied warranty, section 14B. पढ़ा है आपने implied warranty. Doctrine of caveat emptor 16. In a sale by sample, the implied condition is that the bulk will correspond with the sample. Buyer shall have the reasonable opportunity of comparing the goods with the sample, and the goods shall be free from any latent defect. Fine. पेटेंट डिफेक्ट है तब तो ये देख ही लेगा, लेटेंट डिफेक्ट नहीं होना चाहिए, है ना. मतलब हिडन डिफेक्ट नहीं होना चाहिए, हिडन. देयर शैल नॉट बी एनी हिडन डिफेक्ट. Under which provision of the Sale of Goods Act it has been provided that unless the goods are ascertained, the property of goods no property in goods passes to the buyer. 18 देखना, 18 देखो उसमें अनएसर्टेन्ड गुड्स में प्रॉपर्टी पास नहीं होता है. ठीक है. Goods are said to be in deliverable state where the buyer is bound to take delivery under the contract. Nemo dat quod non habet 27. Seller includes seller's agent, अभी आपने देखा 45 में ही. Unpaid seller can exercise his stoppage of goods in transit where the buyer becomes insolvent. Stoppage insolvent में होगा. 63 reasonable time, question of fact. 57 damages for non-delivery of goods. Fine. So we are done with Sale of Goods Act. Fine. Remember a few points. I'll take just 2 minutes. Remember a few points. First thing, be it any legislation, take a notebook, take a pen, write the index. Index में you will be writing the important section numbers, you will be writing the number of the chapters, you will be writing the total number of sections. Fine. जैसे सेल ऑफ गुड्स एक्ट में 7 चैप्टर्स 66 सेक्शंस. फाइन. इंपॉर्टेंट सेक्शंस जो मैंने पढ़ाए हैं वो आप एक जगह लिख लोगे. ठीक है, ये सबसे पहला काम. सेकेंड थिंग, डू नॉट बी इन अ हरी इन द एग्जामिनेशन सेंटर. आप एग्जामिनेशन सेंटर गए हो एग्जाम देने के लिए, ध्यान से वहीं बैठो. 2 घंटे का समय मिला है, 2 घंटे पूरे कंज्यूम करो, अच्छे से क्वेश्चन पढ़ो, 2 बार क्वेश्चन पढ़ो, उसके बाद आंसर लिखो. ठीक है. राजस्थान इज वन ऑफ द मोस्ट ईजीएस्ट एग्जामिनेशंस which any state can or any high court can ever conduct. Fine, most easiest. ठीक है, इसलिए फोकस ऑन इट. इस बार अटेम्प्ट दे रहे हो, इस बार पहले पीटी निकाल लो, फिर मेंस के लिए वी आर हियर. फाइन. ठीक है, चलो फाइन. थैंक यू.